Lordship, I am mentioning review application for inclusion in the list.
Review.
Yes, Lordship.
Have you served notice?
By today, I'll serve, Lordship. New matter, Lordship.
May I be permitted to mention one hearing matter, Lordship?
Of which year?
2014, Lordship.
Notice served?
Notice already served. I have served. By
Give.
grateful to your Lordship.
Any other mentioning? Call the list. এটা গেটের গন্ডগোলটা হয়েছে বোধহয়।
Yes, my lord. Should be 6th. ছ তারিখে বা 9 তারিখে 9/6 হয়ে গেছে।
টেক ডাউন কি আছে? তোমরা Yes, call the list. কি আছে? স্পেশালি ফিক্স করার কিন্তু গেলে বোধহয় পারতাম। মিস্টার চিত্তরঞ্জন পান্ডা, MS কোয়েলি ভট্টাচার্য, মিস্টার স্বপন ব্যানার্জি।
Lord, I am led by Mr. Shopon Banerjee, Your Lordship.
Who is for where is Mr. Chittaranjan Panda? Pass over.
Lordship, I'm for the respondent. I'm led by Mr. Shomu Mojumdar in this matter.
Petitioner is not present. Pass over. Application.
My Lord, I am for
5, my Lord.
3 and 4.
I appear for the petitioner, my Lord.
Cooperative Bank Limited.
I am for the petitioner, my Lord. May I have your Lordship's kind leave to file my affidavit in reply to their applications, to the applications. My Lord, 2 applications are pending.
Give me a second.
Filed affidavit in opposition. The application was filed by them.
Yes. This is my reply to their opposition.
You have filed your affidavit in opposition?
Yes, my lord. The affidavit in opposition, my lord, was taken on record by your lordships on 13th January this year, my lord. My lord's order dated 13th January 2025. The first paragraph, my lord.
Yes. ওই ক্যানগুলো তো বার করতে হবে বাবা, বললেন এই ক্যান 2 of 2019 and ক্যান 3 of 2019 টা বার করুন। Old can 205 and old can 206. আর একটা 206 এখানেই আছে, 206 পাতার পরপর আছে। এটা What is can 205?
My lord, one is for restoration and other is for condonation of delay, my lord. The writ petition was dismissed for default, and for setting aside for recalling such order and for restoration of the writ petition, an application was filed.
And what is another can for?
That is for condonation of delay in filing the application for restoration, my lord.
How much delay?
My lord, I shall be very candid, lordship. It is more than 10 years.
10 years.
Yes, lordship. Yes, lordship. Kindly
Very
consider
good.
this.
You have filed a supplementary affidavit.
Yes, there's a supplementary affidavit as well.
I will hear you. No issue. Have you annexed the order of dismissal
Yes, lordship.
with can 205 or 206?
My lord, that has not been annexed.
No, it has not been annexed, my lord. This is a change brief, lordship.
No, it is please come to can 205. Page number 12, that is the order. Don't have any copy?
My lord, this is a change
Hey,
brief.
এটা দাও,
I'm
এটা
only
ওটা
received the application.
Please see.
Lordship, I'm deeply obliged.
Copy that was out upon me, no answer was there.
Be that as it may.
Yes, lordship, this is the order.
This is the
Yes, my
order.
lord. Yes, my lord.
দাও ওটা দেখি কি বলেছেন। Which one is section 5?
Section 5, lordship, is can 206.
Can 206?
Yes, lordship. 205 is for restoration.
206. This is section 5. Condonation of delay. Yes.
My lord, the petitioner,
What is the original writ petition for?
it was challenging the disciplinary proceeding which was initiated against the petitioner, my lord. That was the original writ petition.
So
You-
what is the prayer in the writ petition?
Yes, lordship.
What was your prayer in the writ petition? Let me see.
The original writ petition was amended.
Yes, lordship.
Can 1999.
Kindly takes up page 14 of the writ petition, my lord.
Page 14.
Yes, Lordship.
Oh, you have paid for setting aside your order of dismissal, I believe.
Yes, Lordship. However, during the pendency, Lordship, if I may just indicate, there was a criminal proceeding ongoing against me. There, I was declared to be not guilty. I, along with another person. Now, my employers have released all the arrear benefits and salaries to the other person. But for some reason, I am being deprived of it. That is what I brought on record with my supplementary affidavit. The petitioner, Lordship, has absolutely no wherewithal. I am appearing almost on a pro bono basis, Lordship. He has nothing, absolutely nothing, my lord. On
The petitioner was an employee of
employee of lordship.
The West Bengal
State
Cooperative
Bank,
Limited.
yes,
He was a
lordship.
branch cashier.
He was a cashier. There was allegations against him.
be that as it may.
Yes.
What is your where from I'll find that with your averment with regard to the delay?
Delay, lordship. Kindly takes up my application for condonation of delay.
Yes.
Kindly turns to para number 5, my lord. 4, lordship.
Please, please.
Page 6, lordship. I've explained the delay from paragraph number 4 onwards.
So your lawyer became ill
Yes, lordship.
from the second week of August 2008,
Yes, lordship.
and he again joined his profession in the year 2018.
Yes, lordship.
So during these 10 years you have did nothing.
I was given to understand that the writ petition is still pending. I had no knowledge that it was dismissed for default. I came to learn about it in 2018 from the clerk of the lawyer, erstwhile lawyer. He comes from a very poor background, my lord. He was completely, utterly dependent on his lawyer. He had no other option but to depend on his lawyer, my lord. It looks very bleak, lordship, but then...
No, in the event your lawyer was in deathbed, you should have made some arrangement.
But my client was under the impression that the writ is still pending. He was not given the information that it has been dismissed for default. It was only after the lawyer recuperated and recovered, that is when they got to know about it.
What supplementary evidence is 5?
Lordship. Lordship, I've indicated here that in the criminal proceeding, I have been declared to be not guilty. There was another individual. Yes,
Criminal
Lordship.
proceeding,
Yes,
criminal
Lordship,
proceeding
is different.
and the departmental proceedings stand on a different footing, you know. It very well.
Lordship.
What was the charge against you?
Lordship.
Defalcation.
Yes, my lord.
Yes, yes, my lord.
Then
But another individual on the absolutely same footing, Lordship, as me, against whom a departmental proceeding was initiated, as well as a criminal proceeding was initiated, we followed the same line of path. Against him also, may I just, yes, I'm not stopping him,
that is the
Lordship.
merit of the case.
Lordship. If my lord is,
What have you got to say?
My lord, so far as the condemnation of delay application is concerned, my lord, my respectful submission before your lordship is that the condemnation of delay application and the restoration application, these two applications are completely speculative in nature. The petitioner was pursuing his criminal case whole hog when he was declared as not guilty by the criminal court. But I have annexed the order by the learned criminal court on 19th April 2018. 19th April 2018, he was declared as not guilty on the basis of benefit of doubt. Thereafter, he came out from his deep slumber to knock the door of this constitutional writ court to get his matter restored, which was dismissed for default in 2008. Thereby, there was admittedly a delay of 3,749 days. In this context, my lord, I have relied upon a reported decision of our honorable division bench, and I have annexed a photocopy of that reported decision in my affidavit in opposition. In affidavits in opposition, both to the restoration application as well as to the application for condonation of delay. There was not a single correspondence, no averment in this line that there was a single correspondence between the petitioner and his erstwhile counsel to know about the details of the matter. The similar was the situation in the case before the Honorable Division Bench, in the circumstances of which their lordships were pleased to observe that the petitioner before their lordships, the appellant before their lordships were not a diligent litigant. That's why his condemnation of delay application was dismissed, though the Honorable Court considered the well-known principles laid down by the Honorable Apex Court in Rafiq versus Munshilal judgment, where the Honorable Apex Court has already been categorically held that if there is merit in the matter, mere delay shall not be the ground to defeat the right of the litigant. It is an established principle by the Honorable Apex Court in the judgment of Rafiq versus Munshilal, reported in 1981, Volume 2, Supreme Court Cases, page 788, that my learned senior friend just now apprised your lordship. And that reported decision was considered by the Honorable Division Bench of our Honorable Court in the reported decision of Gautam Mukherjee versus State of West Bengal, reported in 2018, Volume 5, CHN, Calcutta, page 672. Whenever the judgments of the Honorable Division Bench was pronounced by their lordships, my lord, the Honorable Justice I.P. Mukherjee, as his lordship then was, and the Honorable Justice Amrita Sinha. On 27th September 2018, there was a delay of 3,000 days. Here is a delay of 3,749 days. And It is a well-known principle, my lord,
Straight
that
down.
acquittal in criminal case can't be any ground for interference with the order of dismissal.
That I shall consider at the time of if I allow at this application. It can 2 of
That
2019.
my submissions may be recorded by
Yes,
your
yes. Can 3 of 2019. Just a minute.
At item 6 and 7, I am appearing on behalf of the writ petitioners on in the item number
Just a minute, sir.
6.
I'm appearing for state matter in item 6.
It's for the writ petitioner.
I am appearing the writ petitioner first writ
That
petitioner.
is headmaster matter.
Headmaster matter.
Bakura.
Appointment
Malad.
of
Yes.
additional para.
What is the facts of this case is,
Let the file be placed first.
my lord.
Why so hurry?
আগে writ টা কত? আগে 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 writ টা written, then সকালে। সাধারণত fact পর্যন্ত পড়াই। এর আগে written। এই যে notification টা আগে তত বিতঙ্গ তথ্য ও পেন্সিল আছে আছে 327 2010
So, yes, my learned counsel appearing for the state.
My lord.
You have submitted report and dated 30th January 2025. Just tell me one thing.
Fine.
Whether when
Only my lord.
DPO SSM,
Yes.
after conducting an inquiry,
Yes.
directed the managing committee to take steps
Yes.
for renewal of the renewal of the employment of the writ petitioner.
Yes.
Can managing committee take an opposite direct
They have-
opposite?
My lord, they have, my lord, did not comply with the same. Rather, my lord, they have come up with the second writ application.
No.
Challenging.
What is your contention? Who is the superior authority?
Obviously, my lord, what is controllership that the DPU SSM, when the state thinks that appointment should be renewed further. So the managing committee.
So he has come for implementation of that order,
Only.
that
and he has come for
challenging.
challenging that order. Let me see.
my lord, here is the case, my lord. The my lord, initially the petitioners has already been, my lord, engagement on and from 7th March 2008 to 6th March 2009. Then after having completion, the next year or next stage, that my lord, 7th March 2009 to my lord 2010. 10th May.
You are
2010.
first engaged on?
First engagement on 7th March 2008.
Just a minute. Let me note it down first.
এবং district project officer has been approved on 4th March 2008.
Your repetition number is 25320.
320.
Two five 320 of 2010. With WP yes.
The post is the additional para teacher year-to-year basis on
You
contract
was
basis.
first engaged on?
First engaged on 4th March 2008.
Yes. Then
My lord, it should be renewed by next year up to 19th March 2009. And also executed by the school authority in between the the parties. Read petitioners as well as the school authorities.
from Atto and she was again engaged for second term.
Second term. Now after that, my lord, next year or
Second
next
term.
session, the
Yeah.
petitioners is also under impression that she will be allowed with a renewal. Now all on a sudden,
Just a minute, sir. Yes. Yes, sir.
all on a sudden on 10th May 2010, the
Huh.
concerned school authority, being the secretary of the managing committee, a letter was communicated to the respondent number 5 to that effect that the renewal of the petitioner could not be done as her service has been treated as not satisfactory, and matter has been referred to the district project officer for necessary action. A copy of the resolutions dated 10th March.
Who is
10th
the
May.
appointing authority?
Appointing authority is the school managing committee.
At the recommendation of anybody?
No, recommendation, that means first of all appointment, then it should be approved by the concerned project officer under the SSA. This is the guide and procedure.
Well, may I interrupt for a moment? That was not the system. The system was the managing committee insofar as.
No, I shall hear you later. Yes.
And 10th May 2010, this secretary has been wrote a letter to the project officer as well as the respondent number 5 that her service has not been satisfactory, treated as not satisfactory, and necessary action to be taken.
Give me a second. So your selection was by the selection committee.
Selection committee.
Subsequent to the approval of the district project officer, Bakura. That is the paragraph 4.
Yes.
Yes.
Then
Your
my lord,
service was not found to be satisfactory.
found not satisfactory,
And matter has
but
been
that
referred to
letter
the
was
DPU.
issued by the secretary on 10th May 2010.
Yes.
And with a resolutions copy has been forwarded to the project officer for taking necessary action.
Yes.
Against that, a writ petition was filed. That writ petition is being annexed, your lordship kindly see that writ petitions being WPA number, that is page page 24, there is WP number 14327 W of 2010. By an order dated 28 July 2010 of my Lord Justice, my Lord Dipanko Dotto, as his lordship then was. Now here is the, my Lord, the order regarding the not satisfactory service. It was not been renewed by the secretary. Now the order has already been dictated by your lordships. The petitioners was engaged as an additional para-teachers in Bhedua, Salboni,
Read from page 25.
relevant paragraph, my lord,
Page 25.
25.
Yes.
Having regard to the nature of the controversy raised herein, this court finds no reasons to keep the writ petition pending. The same stands disposed of with a direction upon the district project officer to conduct inquiry for ascertaining whether the performance of the petitioner was in fact unsatisfactory as alleged by a school or not. Such inquiry shall be conducted within 7 days from the date of receipt of a copy of this order. The report of inquiry shall thereafter be placed by the district project officer, Sarvashikha Mission, Bankura, before the district project director, Sarvashikha Mission, Bankura, for this final decision. The district magistrate shall decide the issue within a further period of 2 weeks from date of receipt of report from the concerned district project officer. In the event the decisions of the district magistrate is adverse to the interest of the petitioner, the same shall be supported with reasons and communicated to her. On the contrary, if the allegations of unsatisfactory performance is not found to be well substantiated, the district project officer shall issue direction on the managing committee to re-engage her by executing fresh contract. There shall be no order as to cost. So, my lord, ultimately, direction has been given regarding this satisfactory for an cost and inquiry report to be finalized by the director of the SSA.
Show me the order of the district magistrate.
My lord. Then your lordship kindly me at page 26. District project officers, my lord, has been compliance in regard to this court's order. In compliance with the order passed by Lordship Justice Dipankar Dotto in the above mentioned writ petition, an inquiry was caused by District Project Officer Sarvashikha Mission Bankura, which was duly placed before the District Magistrate Bankura and District Project Director Sarvashikha Mission Bankura for his final decision. As per decision, it is found that the grounds cited by the school managing committee for non-renewal of the contract SMT Purnima Dandopar, that is the first writ petitioner, as para-teacher in Bhedua Salboni Navasikha Mandir is not satisfactory and does not. Thus, it is directed to the concerned school managing committee for taking immediate necessary action for renewal of contract of SMT Purnima Dandopar by extending fresh contract. This is the order passed on 10th September 2010. Thereafter, my lord, the school authority did not take any steps.
So, what is the finding of the district magistrate?
Well, finding of the district magistrate, that is the project officers has already been taken a decision because it has been as per decision. As per decision, it is found that
No.
Cited by
Come back to 25.
My lord.
The report of the inquiry shall thereafter be placed before the district project officer.
Yes.
Before the district project director.
Yes.
For his final decision.
Yes.
The district magistrate shall decide the issue within a further period. So, where is the finding of the district magistrate?
That findings, my lord, cited by the district project officer, page 26. There is the second paragraph of his order. As per decision, it is to be found that the grounds cited by the school managing committee for non-renewal of contract SMT Purni Devan and para-teachers in Bhedua such and such not satisfactory and does not end. Thus, it is directed to the concerned school managing committee because it has been obtained. It has been obtained
the
from
finding of the district magistrate that I intend to know.
Well, that record is developed by the state.
The district magistrate has not taken any decision.
No. That has been taken.
That has been taken.
That is, I find that is not with the in the record. My lord, although my lord, the DPO has in the DPO's order as page 26, it has been reflected.
Yes.
That is lordship pleases, so I shall again my lord come up with inquiry report. Since in terms of my Justice Dotto said an inquiry should be conducted, then in terms of the same page 25, the report is thereafter be placed to the district project officer. Sarvashikha Mission.
No, director. District project director
officer,
as well as the district.
Bankura before the district project director, Sarvashikha Mission Bankura for his final decision. Now, ultimately, this somehow, my lord, that part is not in the record, my lord, page 26. It says, my lord, the district project officer says in compliance.
No,
with
the direction of the honorable coordinate bench that
yes, my lord.
the district project officer shall cause an inquiry,
My lord.
submit a report to the district project director,
Director, yes.
and for his final decision.
Yes.
And the district magistrate shall decide the issue.
When the decision of the district magistrate is adverse to the interest of the petitioner, the same shall be supported with reason and communication. Now, page 26 says, in compliance with the order passed by His Lordship Honorable Justice Dipankar Datta in the above mentioned petition, an inquiry was caused by the district project officer, Sarvashiksha Mission Bakura,
which was duly placed
before the district magistrate.
District Magistrate
Bakura
and District Project Director.
Sarvashiksha Mission Bakura for his
Final decision.
As per the decision. So
Yes,
the
yes,
decision
which was duly placed before district magistrate
Yes.
for his final decision.
Yes.
Now, as
And
per the
so he is communicating this order.
yes.
This
Yes.
matter.
So the decision before the
Decision has been taken by the district
that
magistrate.
in
Yes.
favor of the petitioner, the
Yes, yes.
inquiry, my lord, has
That I mean, why are you not showing this portion?
My lord, then my lord, page come to page number 29.
Now, my lord, just 1 second for that. By this same letter, it is found that the ground cited by the school managing committee is non-renewal of the
Absolutely,
Yes,
absolutely.
No,
it is taken in favor, and school was directed to immediately to proceed with the renewal.
Then what happened, sir? Yes,
Then-
take your seat.
Then my lord, next page 27, that directions for that order has not been implemented by the school authority. Then my lord, the petitioners made an applications to the district project officer.
Place the letter.
My lord, page 27. With deep respect and regret, I beg to inform you that in compliance with the order passed by the Honorable High Court, Calcutta, and with reference to your intimation by memo number such and such, dated 10th September 2010, the concerned school managing committee has not taken any necessary action for renewal of my engagement. The school managing committee has issued your directions of the Honorable Court's order. I think is beyond the dignity of your office, so I request you to take immediate action for renewal of engagement as parateacher since 9th March 2010. Otherwise, I shall be compelled to take further shelter in court for contempt to court order to all the respects. That thereafter,
So same letter was addressed to
district magistrate.
district magistrate.
My lord. Then, my lord, kindly page 29, by letter dated 1st November 2010, it has been, my lord, wrote a letter to the, my lord, district project officer SSM Bakura by the additional state project director. Enclosed, please find herewith letter under reference in the above subject, which is self-explanatory. He is requested to necessary steps for implementation of the order of the Honorable High Court within the stipulated time. Development of the matter may be communicated to this end in due course. There is the project director's letter. Also informed to the district project officer. And also a copy to the writ petitioner. But after that,
Despite issuing that letter, they have not issued.
they have not issued.
They have not restored your plan.
Yes, my lord, not taking
So what is their affidavit in opposition?
oppositions, my lord, that oppositions, my lord, has been directed.
Affidavit in opposition টা কোথায়?
That writ petition, my lord, has not been complied with the honorable court's order. A contempt was filed. Now, then and there, the committee has already been filed a second writ petition.
No. I shall go to the second writ petition. What is their case in the affidavit in opposition?
Well, there is no any directions for filing affidavits.
Huh?
There is no any direction for the filing of the
Now,
earlier.
why affidavit in opposition on behalf of the respondent number 4 and 5? Who are they?
No, my lord, I have filed the affidavit in opposition. My learned friend had used the affidavit in reply also.
No. That is the present case. Present both the writ petitions regarding the affidavit I have.
No, they have filed their affidavit in opposition.
Yes, my lord. Affidavit in oppositions I have already filed in regard
Have you
to
not
this
gone
matter.
through the brief?
My lord.
I am asking
My lord.
against your writ petition, what is their case in their affidavit in opposition?
that is their case, my lord, the regarding this, my lord, the disturbance of the, my lord, the guardians has been claimed to the school that the concerned teacher.
Sir, show the relevant paragraph. Why are you so casual? পড়েই আসেনি মনে হয়।
আমাদের অপোজিশন নেই,
There must be some justification on their part, whether that is acceptable to the court or not, that is different thing.
no
In their
direction.
affidavit application, what justification they have given?
My lord, pursuant to the order.
Show me the relevant paragraph first. What is their case in the affidavit opposition?
My lord,
As affirmed on 3rd August 2011.
স্কুল অথরিটি অপোজিশন দিয়েছেন হয়নি, দিয়েছেন
2010-এ?
দেখেন না।
এই তো
ভগবান জানে, ভগবান জানে, দুটো না তিনটে আছে। Yes. My lord, their opposition is, my lord, in regard to this, my lord, the first matter, there is the 25320 of 2010. My lord, para 2. এটাই তো কাজ। My lord, your lordship kindly, my lord, page 5. দশ পাঁচ 2010 পরে ও চিন্তা তো একদম আন্ডারলাইন করে দিয়েছে রেড ক্রাই। আমার তো একবারে রেড ক্রস সোসাইটি।
So after 10/9/2010, what they have done?
My lord, your lordship kindly, my lord, page 5 of their opposition,
Huh.
which has been affirmed on, my lord, 3rd day of August 2011.
That I know.
My lord,
So what is their case? Why they have not complied with?
my lord, my lord, without any reasons, they did not, my lord, only
So
many,
how they have
many
dealt with
occasions.
their case? How they have dealt with your case in their affidavit opposition? What is the play? Predicate, have you not read?
My lord, page 5, my lord, your lordship kindly para 7. Para 7.
Yes.
My lord, prior to that, para 6, that before the meeting dated 9th May 2010 of the managing committee of the school, a deputation was given by a political party to the respondent number 5 herein on 16th April 2010, pointing out the some irregularities.
Sir, what is the date? What is the date of what is the date of communication of the letter by the DPO to the school?
There is school 10th May 2010.
May not 10/9.
10th May 2010.
Communication means, my lord, that main
issue this letter, my lord, regarding, my lord, non-satisfactory or not renewal. That is their school authority's intention.
Sir, the impugned letter of communication is dated 10/9/2010.
10th/9.
page 26.
तो महा मुश्किल
Yes.
পড়ে আসতে
My lord, I'm sorry, my lord, sorry.
মহা মুশকিল है বাবা।
Page 26 টা দেখেন।
So why do not
26.
what is the
26.
predicament? I mean, ready before this
my lord, 10th September 2010.
with
No,
the
my lord.
fate of your client.
My lord, 10th September 2010, it is my favor.
What
Direct-
happened? What is their case that as to why they have not complied with the order dated 10/9/2010? That is relevant for disposal of the
That's why, my
insolvency
lord,
notice.
in regard to this affidavit in opposition has been filed by the school authority stating all these things in regard to this, my lord, 10/9/2010 as to why we are not, my lord, contact
So
basis
you have
has
not
been
gone through their affidavit in opposition. Try to be honest.
my lord.
After 10/9/2010, what the school authority has dealt, what the school authority has done, have they dealt with in their affidavit in opposition?
No, but that is, my lord, their questions, my lord, been separate. Renewals grounds is that not satisfactorily, cannot not satisfactorily, that was not, my lord, disclosed in their letter. Only resolution copy has been forwarded to the district project officer for taking necessary action. Now, after that, this writ petition has been filed in regard to this, my lord, 10 September 2010 as to why this order has not been implemented by the school authority. There is no ground. Then they have used this in opposition to the second time in the writ petition. Because it has been, my lord, crystal clear by this honorable court of my lord Justice Dato. That so far the non-satisfactory of the petitioner's renewal is to be, my lord, made an inquiry. Inquiry was made. Even after district magistrate as well as the director, project officer has been intimated that yes, he is requested or school authority is requested to take immediately steps for renewal for a fresh contract. That agreement has not yet been done. There is no any cogent ground by the school authority. Now, my question is this, but the second writ petition. Guidelines.
Very good. Take your seat. Sir, what is the stand of the state?
Yes, ma'am. Our stand is, my lord, super, my lord, position is
So far,
concerned.
this writ petition is concerned.
This petition is concerned, my lord. We shall, my lord, already it was placed before the lordship that in terms of the convenience bench decision, inquiry conducted, that was placed, approved that chronologically every possible steps was taken. Ultimately, petitioners was recommended for appointment or renewal of her contract. That is a page 23. Up to that part, my lord, the state has, my lord, considered her to. Now, for what, my lord, they were bound to follow that higher official's decision, but we could not take further steps. My lord will be, my lord, maybe, my lord,
That direction is
from us that why they have not taken further steps. They have come with another writ application challenging this page 26, and it was kept pending for long. And by that time, only one problem is there, that as of now the law has changed. Law has changed. Now, in 2010, subsequent thereafter, it was the policy decision was taken that for continuation of service of the para teacher up to 60 years.
But
That has
done.
been,
So those who are in service,
Who are in
their service is extended to 60
yes.
months.
And
Only difference is that instead of 1 year-to-year revalidation, their services for fixed
Up to
period of
up to 60 years.
60.
That's right.
Now, as of now, what that
52.
decision is not there. That is, but as of now, there's a power upon the school is not there for the fresh renewal or fresh appointment of parents. Absolutely, there has been no further engagement of parents. This is the position.
So in the,
appointment to me.
so what will be your stand in the event this
That's
repetition is allowed?
No, yes, that should be given effect. Now the position is that I have specifically talked with the DPO, but they said as of now we directly, since there is no law, we cannot direct the school that now you engage. Under what law will be granting if the honorable court directs? that
Seven
will be-
accept the
Very
contract.
good. What is your contention, sir? I understand.
My lord, I have already used my affidavit in opposition in the first writ petition. But for my lord's convenience, if my lord kindly takes my writ petition, my lord, I
That is at
1111.
1111 of 2011.
If my lord kindly takes that, my lord, I have disclosed the whatever documents are there,
দেখি
whatever
দাও তো ওই রিট পিটিশনটা দেখি ভাই
are there.
Sir, it is a request to you. Whenever you approach before this court, come ready.
My junior could collect this paper regarding oppositions and reply. But I have just now I have. Those records are missing.
So here the rit petition is the school.
School, my lord. But
These gentlemen are still there.
no, these gentlemen are not there. Then
So what is the present? What is the stand of the present committee?
the present
Why is
committee?
why is the headmaster?
My lord, headmaster is there, my lord, on the online. Headmaster is there. The headmaster is the secretary. Now they
ওনাকে
have
নিন তো লাইনে।
decided, my lord, that
ওনাকে নিন একবার আমি নিন এসেছেন আছেন
this is the difficulty at the very first day I submitted.
yes yes
দাঁড়া কোথায় ফোন করবো ভাই এখন?
আপনি আমার কথা শুনতে পাচ্ছেন?
মাই লর্ডশিপ শুনতে পাচ্ছি।
এখন তো ওই কমিটি আর নেই, এখন তো নতুন কমিটি।
না, হ্যাঁ মাই লর্ডশিপ নতুন কমিটি।
আপনি সেক্রেটারি,
আমি সেক্রেটারি মাই লর্ডশিপ।
আপনি প্রেসিডেন্ট।
No, no.
না, প্রেসিডেন্ট
আপনি হেডমাস্টার,
হেডমাস্টার।
তো ডিএম সাহেবের অর্ডারে ডিপিও আপনাদেরকে কমিউনিকেট করেছিল যে রিট পিটিশনারকে নিয়ে নেবার জন্য, যে কোনো কারণেও আপনারা নেননি। এখন কি অবস্থা? আপনারা নিতে চান না?
মাই লর্ডশিপ অনারেবল হাইকোর্ট যা ডিসিশন দেবেন আমরা মেনে নেব।
ভেরি গুড। So I can dispose of this.
But kindly see why the appointment was not given. At least that should be considered.
Give me
My lord, don't take the report filed by the district project director or officer as sacrosanct. Kindly don't take it. Because the fact remains, no inquiry did take place. No inquiry did take place. The school authority ran from pillar to post. That what is the inquiry? What is the order of the district magistrate? Kindly let us know. Kindly supply us a copy. Kindly supply us a copy of the inquiry report so that they can see.
Is there any direction? Is there any direction of the earlier coordinate bench
My-
that
My
it
lord,
will be
this is-
communicated to
my lord,
along with the inquiry report?
my lord,
He will consider the
My lord,
inquiry report.
my
He
lord.
will give your consent.
No, no.
Thereafter, they
Well,
will take a
question of
decision.
question doesn't arise. Your lordship, can you see this comes within the domain of principles of natural justice. Whenever some inquiry will be conducted against me, in where the inquiry will conduct, it's not within the four corner of the DPO's office. The inquiry has to be conducted in the school itself. If the inquiry is conducted, obviously the school authority, the managing committee, they will be made aware that such and such inquiry will be held. At least if such inquiry was practically held, they would have been aware of the situation. It is not there. It is not there. And there is every
Who
reason.
is the appointing authority?
But at that point of time, the managing committee was the appointing authority. Managing committee forms a selection committee. And my lord, advertisement was made in the local panchayat and conspicuous places. Then, my lord, the selection used to take place. But
You are the functionaries of the state. How do you challenge the action of your superior?
my lord, I am not the functionary of the state in that sense. I am a school, my lord. I have some autonomy. Your lordship, I can challenge because if some, my lord, your lordship,
দেখি ওনার ডিক্রিশনটা কি আছে দেখি একবার।
your lordship will see if some blame is to be put on the school authority, if a threat is there that if you do not do that, the school will be closed.
কই দেখি এটা
Apart from this kind of submission is coming that.
I do not know, possibly my learned friends should keep
সেকেন্ড
mark.
ফাইলটা দিন
I shall place one after another document.
That there has been threat that
Yes.
school will be closed unless
Yes.
the petitioner is appointed.
Yes,
It is
yes,
sustained.
yes, that is there. I am not saying something, my lord, because this is not the
So
right.
what is the basis of your writ petition? Let me
Your
see.
lordship will kindly straightway come to the annexures. That will, my lord, do. My lord, this is the first page at page 31. Your lordship kindly see the first notice. The first notice for first selection.
Although, my lord, that second writ application, I am not appearing, my lord. I am unaware of the ground of the writ.
Let me see.
Yes,
That,
yes. Your lordship kindly see. This is the first. Then, my lord, the resolution of the managing committee.
Second writ, sir.
Your lordship, here I have to say one thing, that what was there. The
No,
advertisement.
it was taken care by the earlier coordinate bench.
No,
Huh?
no, there was no such occasion because I could not. Your lordship will find from the order of my lord Justice Dotto that since I could not produce the record, because the record was not readily with me. I shall, my lord, I shall place. Let me place, my lord.
Very good. Please.
Then your lordship kindly come to page 31A.
31.
31A.
So what is page number 31?
31, my lord.
Initial appointment letter.
No, it's not initial appointment letter.
Then
It's a notice, my lord, regarding filling up of the post of a para teacher.
That is the
Oh,
initially for filling up the post.
seeking it. Don't jump, sir. So seeking application
Seeking application.
are requested
For
to
the
turn up.
first term, you will also kindly see for first year.
Yes.
This is there.
Hmm.
Then, my lord, the resolution was taken at page 31A.
What resolution you have taken?
The resolution was taken that it has to be notified.
Then
This notification was there, and it appears, my lord, that on the same day it was posted. Then, my lord, an interview took place. I'm not going into the jargon of the fact that how this abrupt situation this was done, and what was the reason behind this. Because I'm refraining myself from making any comment. The next page is, my lord, single panel, page 32.
selection of the writ petitioner.
Only one candidate appeared at the interview. That is the writ petitioner, my lord, in 25320.
Yes.
Then your lordship will kindly come. Kindly come, my lord. 4/3/2008. আচ্ছা একটু বল, আমি একটুখানি শান্তিতে বলি।
ঠিক আছে।
Then, my lord, approval from the office of the district project officer, page 33. My lord has got it, my lord, 4th. 1, 2, 3, 4, 5th. Purnima Dandopat.
Yes.
Next, my lord, your lordship will kindly come to page 35.
Yes.
The first appointment letter.
Yes.
The engagement will be purely temporary and contractual basis for 1 year from the date of joining, provided his or her service in the institution is found satisfactory throughout the period of 1 year on a consolidated pay of 3,000 rupees, such and such. You'll also kindly take a note, provided his or her service in the institution is found satisfactory.
No, of course.
My lord, this is the catch. Kindly, my lord, take a note of the fact that it's a contractual appointment, even if today. It's a contractual appointment. Because satisfactory service is the prime consideration. And more prime consideration is, my lord, it's for the interest of the student. The school appoints teacher, my lord, be it para teacher or a regular teacher, is for the student. The school is not meant for appointment of teacher, irrespective of requirement of irrespective of satisfaction. Teacher is for the students. Students are not for teachers.
Then
My lord, your lordship will kindly see page 36. Kindly read, my lord, the first paragraph only. That will suffice. বিদ্যালয়ের পার্শ্ব শিক্ষিকা পূর্ণিমা দণ্ডপাঠ মহাশয়ের বিরুদ্ধে পূর্বে কোনো অভিযোগ একাডেমিক কাউন্সিলের নিকট জমা পড়েনি। এছাড়া বিদ্যালয়ের একাডেমিক কাউন্সিল তথা স্টাফ কাউন্সিল এটা ইটস এ সাবসিকুয়েন্ট রেজলিউশন ভিত্তিতে দণ্ডপাঠ মহাশয়ের রিনিউয়াল দেওয়া সম্ভব হলো না অভিভাবক সদস্যবৃন্দের অভিযোগের ভিত্তিতে। ইউর লর্ডশিপ উইল কাইন্ডলি সি, ইটস দি গার্ডিয়ান হুজ ওয়ার্ডস আর বিং টট ইন দি স্কুল। অভিযোগের ভিত্তিতে রিনিউয়াল দেওয়া সম্ভব হলো না। Now, my lord, may I go further? Then your lordship will kindly see page 38. When the DPO was intimated, whether it is prior to the order passed by Justice Datta or after, to the DPO SLSM Makuda, মহাশয় পার্শ্ব শিক্ষিকা শ্রীমতী পূর্ণিমা দণ্ডপাঠের সার্ভিস স্যাটিসফ্যাক্টরি না থাকার জন্য সরকারি আদেশ মোতাবেক তাকে রিনিউয়াল করা যাচ্ছে না। স্কুলের প্রধান শিক্ষক মহাশয়কে অনুরোধ করা হলো যেন এই সিদ্ধান্ত মাননীয় ডিপিও মহাশয়ের নিকট পাঠানো হয়। It was duly sent. Next, my lord, this is the order, and my lord has gone through the order. Now, your lordship can see, when this order is passed, it is implicit in the order that against a person, if an inquiry is held, he must be made aware. Against a person, if an inquiry is held and an order is passed, he must be made aware of the order. But for this, no fresh direction is required. It's a question of fair play in action. It's a question of principles of natural justice. Your lordship will appreciate if an accused, my lord, is tried without being heard and is hanged.
Have you taken the point with the DM?
Yes, my lord. Yes, my lord.
Have you taken that point into the DM?
I'm coming.
Before the district magistrate, have you taken that point?
Well, I have stated, I have sent every paper.
No. Prior to filing your writ petition,
Yes.
have you taken this
But
point
prior
to the
to
district magistrate?
filing of the writ petition, I sent all papers to even up to the director of Sarvashik Commission.
Sir, don't try to
No,
even.
I'm not. I'm
Sir,
pressing
what
my-
I'm on,
Yes,
you have received the communication of the DPO
yes,
with regard to the decision as taken by the district magistrate as well as the district project inspector.
yes.
Have you made any correspondence during the period of communication of that letter and during the filing of this writ petition, that the report as has been submitted or as has been communicated by DPO is faulty because you have not given me a chance to ventilate our grievance.
I'm coming.
I would taken that point that I wanted to.
I'm coming. Your lordship, now come to page 41.
Yes.
Now it's a complaint of the guardians against Purnima Dandopat. Your lordship, kindly see the receiving. Is central receiving success Bankura collected means, my lord, district magistrate. Left hand side.
Who has written it?
Yes, my lord.
Who has written it?
These are the guardians of the school, students of the school.
Oh, they are not before us. Sir, why are you avoiding my
But I am
question?
not avoiding. Your lordship, kindly see. I have to go, my lord, step by step. Step by step. It's a
I got your point.
My-
Have you
my-
taken
my
have
lord-
you taken
my
the
lord-
matter with the district magistrate
my lord,
that I am not going to implement your order in view of the fact that the inquiry as conducted by you is faulty because I have been deprived of the audio altering pardon that I intend to do.
Here, lordship, kindly see what the school authority can do. Next, page 45. These are, my lord, it's my lord, prior to the order passed by the honorable court. Next, page 45.
All political parties, etc., etc.
Not political party. Where
Hmm.
political party? Where political party? I have not said that Purnima Dandopat was appointed by the wife of the then MP from CPIM. I am not saying that. It is there. I was not opening my mouth. Forget about that, my lord. Forget about the political party's interest. And your lordship will find that the change
Sir,
of
your headmaster is willing to do.
no, headmaster will comply. But when my lord will pass an order, my lord will consider all these things. And why I am saying, your lordship kindly.
Sir, where is the just show me where is the justification for not giving compliance?
Justification, my lord, because there was allegation of leaking of question paper by her. Allegation was
That has been taken care of by the district magistrate.
where? Where from I will get it?
So why you have not agitated that point before the district magistrate?
But that's why that after later it was written, no answer, nothing of this sort. Even my lord.
Show me those letters.
Yes, I'm coming.
Show
I'm
me
coming.
those letters.
I'm coming. Kindly come to page 47. Request for the inquiry report and all these things. Because my lord, I did not have any business to the district magistrate directly. I can only write to the district project officer.
Yes.
Kindly see. It's a letter on 29/2010, immediately after the letter of September 2010. And kindly see, my lord. Everything, my lord, by Mayor, like Mayor chanting a mantra that has been complied with. No inquiry was held at the district magistrate. The inquiry report was placed before district magistrate. District magistrate passed an order, and a cryptic order has been communicated by the district project officer that found not satisfactory. Will this do? Again, my lord, come to page 49. I once again fervently request you to send a copy of the inquiry report regarding non-renewal of the contract of service of Purnima Dandopat, para teacher, that is followed by the direction of the Honorable Court by the managing committee, may take step to comply with the order of the Honorable High Court. Where is the report? Well, are they not creature of law? Are they not creature of statute? Was it not their duty? It's not a confidential document as such. It is not prevented under the Official Secrets Act. Then, my lord, kindly come to page 50.
Your letter number 50 is contrary to page number 36. Take down.
Page number 36.
Your letter,
Yes,
at page number 50,
yes,
written by the then secretary of the school,
yes.
is contrary to page number 36.
Kindly, my lord, let me.
I have seen.
Your lordship, kindly read page 51.
Yes, I have read, sir.
I have written. তিনি বিদ্যালয়ে যে
এই অর্থে আপনাকে জানা যায় শ্রীমতী দণ্ডবাদ তার কাজে চরম অবহেলা করিতেন, বিদ্যালয় কর্তৃপক্ষকে অবজ্ঞা করিতেন। তিনি ড্রপ আউটদের বিদ্যালয়মুখী করা বা শিক্ষায় পিছিয়ে পড়া স্টুডেন্টদের স্পেশাল কোচিং এর করার কোনো ব্যবস্থাই নিতেন না, কারণ তার রাজনৈতিক প্রভাব ও কোটিপতি বাড়ির বৌমা হওয়ার প্রধান শিক্ষক ও সহশিক্ষক এবং পঠন পাঠনের কথা বলা তো দূরস্থ, তার সমস্ত কাজে ও কথায় সমর্থন করিতে বাধ্য হন। নাও কাম টু ইউ পেজ নাম্বার 36.
Yes.
বিদ্যালয়ের পার্শ্ব শিক্ষিকা পূর্ণিমা দণ্ডপাঠ মহাশয়ের বিরুদ্ধে পূর্বে কোনো অভিযোগ একাডেমিক কাউন্সিলের নিকটে জমা পড়েনি। এছাড়া
মানে
একাডেমিক কাউন্সিল তথা স্টাফ কাউন্সিলের দণ্ডপাঠ বিরুদ্ধে কোনো অভিযোগ নেই, কিন্তু বর্তমান অভিভাবক সদস্যের অভিযোগের ভিত্তিতে দণ্ডপাঠ মহাশয়ের রিনিউয়াল দেওয়া সম্ভব হইতেছে।
My lord, academic council is a just body constituted by managing committee. It's not above the managing committee. Kindly appreciate academic council
Take down.
is such a body.
I got your points.
May refer, my lord, some judgments.
Yes.
Yes. The first judgment is 99 Supreme Court cases, labor and service, page 620.
99.
Supreme Court cases, within bracket, labor and service, page 622.
Page?
622.
Yes.
Yes, my lord. শুধু ভলিউম দেখলে হবে শোনা আমার না
Yes.
Paragraph 9 and no, sorry man, and it's a matter relating to, my lord, dismissal, my lord, and non-renewal. The principle which has been held in this case, that এটা কোথায় গেল, এটা তো নয়। Paragraph 7, my lord, we find principle is, my lord, that non-renewal, they do not have any right to be renewed as such. খবরদার দিবি না।
Next, sir. Anything more?
Yes, ma'am. Next judgment would be, my lord, 1993 supplementary 4 SCC, page 46.
1993,
4 SCC,
1993 supplement,
supplementary 4 SCC, page 46.
supplementary 4 SCC 46.
Page 46.
Yes, sir. Para.
Paragraph 6 and 9, my lord, will kindly cover 6, 7 and 9.
Yes. Please.
Yes. The High Court has found that the appellant was not eligible for promotion to LT grade on August 29, 1977, when the post of LT grade teacher in whom service was created for the person that the appellant was not a trained graduate on the relevant date as required under the notification. Such and such, in view of the High Court, by holding qualifications mentioned in Appendix A to the resolution, a person could claim appointment only in the CT grade. Would find it difficult to subscribe to this view. The promotion from CT grade to LT grade is governed by clause 1 such and such, having a minimum of 5 years continuous service on the date of occurrence of the vacancy and possessing the prescribed minimum qualifications for teaching the subject in which the teacher in lecturer grade or in the LT grade is required. Next paragraph, my lord, it is not disputed that the appellant possesses minimum qualification. Next paragraph 9, in the aforesaid reply, which was given in paragraph 8, would show that on behalf of the respondents to 1 to 4, it was not disputed that 40% posts which have to filled up by promotion had not been filled up by denial of promotion to the appellant was justified on the sole ground that she was not qualified to be promoted. This shows that the pleadings before the High Court, there was no contest on the question that a post of LT grade which was sanctioned on such and such was required.
Why it is relevant, sir?
Relevant, come. High Court has gone into it and has held, next page, held and that appellant has failed to establish a case on such and such. The total number in the college were not filled up. Since no dispute was raised, why I am saying, my lord, why I am relying, my lord, I shall submit this. No dispute was raised on behalf of the respondent 1 to 4 in their reply to the amendments made in the appellant in the writ petition that 40% of the total number such and such filled up by promotion inasmuch as the said amendments had not been controverted. The High Court should have proceeded on the basis that said amendments had been admitted by the respondents. I am on that only. In this case, my lord will find that despite direction of affidavit, the state respondents have not controverted the contentions raised by me in the writ petition. In absence of any dispute, whatever I have stated has to be taken to be true. The last 2 lines of paragraph 9 is very important.
Since no dispute was raised on behalf of the respondent 1 in the reply
Yes.
to the amendment made by the appellant in the writ petition that 40%
Yes.
have not.
Here, no reply even was there. In absence of any reply, it is settled proposition, my lord, that if my contentions have not been disputed, the same has to be taken to be true. The same has to be accepted, my lord. It's not, my lord, today's principle. My lord. Whatever I have stated,
on the basis of their lacuna, you will succeed.
no lacuna.
You don't have any responsibility to prove your own case.
No. He will, my lord, put on the basis of that, on the basis of the writ petition, who is representing the state. Let them say, my lord, why this copy was not supplied.
That's all.
No. Further judgment are there. Further judgment are there. At least, my lord, let me have my satisfaction to place, because I have thought about the matter. Kindly see 2006, volume 1, SCC, page 368.
2006.
Volume 1, SCC, page 368. Paragraph 9 and 11. This is for the proposition that whatever the order has been passed and whatever the reliance has been placed by my learned friend, my lord, in respect of another judgment which has been disclosed in the writ petition, in her writ petition. Kindly see, because the judgment, the facts and circumstances.
Sir, kindly place.
Yes. The court should not place reliance on decisions without discussion discussing as to how the factual situation fits with the fact situation of the decision on which reliance is placed. Observations of the court are neither to be read as Euclid's theorem nor as provisions of the statute, and that too taken out of their context. This observation must be read in the context in which they appear to have been stated. Judgments of the courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark into lengthy discussions, but they do not interpret judgment. They interpret the words of statute. Their words are not to be interpreted as statute. But then a judgment has been referred to. Foreign judgments are referred to, my lord. It has been stated then. Paragraph 11, my lord. This is very important. Circumstantial flexibility. One additional or different fact may make a world of difference between the conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper. Your Lordship, kindly consider, here my learned friend has referred to a division bench judgment. That is there, my lord, they have disclosed it. That judgment, my lord, on a different context. And admittedly, I appeared there. The facts and circumstances does not fit with this. And my lord, once again, at the risk of repetition, I am submitting that whatever my communications were there, it was the bounden duty. But it's normal course, if a representation is made, it has to be dealt with and disposed of before representation made before the authority. In the instant case, my lord, the district project officer, not the DI, not the director of Sarvashik Commission, no one has come, my lord, to refute my contention, nor any response was given to that effect. Kindly consider this aspect of the matter, and my lord will also kindly give an observation as to whether we are entitled to know that without inquiry how an inquiry report was placed, or practically whether there is any order from the district magistrate, because nothing is there, seven except the communication.
Let
And
me pass my order.
No, that too, my lord, the project officer's report kindly see, it's not on affidavit.
Very good. I shall pass my.
Yes, ma'am. I'm deeply obliged.
Only one point.
I may be given liberty.
Lordship's, my lord, convenience. May I just read page 25, just coordinate bench decision. All my learned senior friend is submitting is just beyond that order of the coordinate bench. It says, in the event the decision, my lord has already paid it. Since my lord further, my lord, in the event, it is page 25 coming from the last few lines. In the event the decision of the district magistrate is adverse to the interest of the petitioner, the same shall be supported with reason and communicated to her.
Yes.
In the event it is that has to be communicated to the petitioner, not to the managing committee. Next, on the contrary, if the allegation of unsatisfactory performance is not found to be well substantiated, the district project officer shall issue direction on the managing committee to re-engage her by executing fresh contract. So all this, my lord, in terms of order, they cannot take this point of non-supply of this is not or not at all, my lord, with the direction of the honorable.
Yes.
But I have submitted, my lord, it's entirely up.
Very good.
And with my lord's leave.
হ্যাঁ call the next matter.
Before taking up hearing matters, my lord, if your lordship kindly takes up Passover.
ফার্স্ট ওভার ম্যাটার কখন হবে? একটা আর্টিস্ট না, ইউ কল দি নেক্সট ম্যাটার।
My lord, I have to put the stake.
I am for the corporation.
তুমি তো বলবে। Lordship, I beg to appear on behalf of the petitioner in this. Before my lord takes up the matter, Lordship, the petitioner is challenging the classification of his property as a heritage property. Lordship, that is the subject matter of challenge in the writ petition. Lordship, we are appearing after filing change in Wakalatnama. Lordship, I have taken inspection of my lord's brief, and Lordship, there is an affidavit in opposition which was affirmed way back in 2012. Lordship, I inquired from my learned senior friend who's appearing on behalf of the corporation, Lordship, if a copy, but he also does not have a copy with him of the opposition that has been filed. Also, Lordship, there was a previous order of this honorable court in 2012 when Justice Ashok Dashodikari, as his lordship then was pleased to add certain tenants who were there in the who were there in the property as party respondents. Lordship, the difficulty now is, since there is an affidavit in opposition and the petitioner has not used a reply, I was praying that, Lordship, I may be allowed to take out a certified copy of the opposition that is there in my lord's record, and I may be allowed to file a reply thereto. And also, Lordship, the other respondents who were added, because those were around 15 respondents were added. The school was a tenant, certain teachers and certain parents. If my lord takes up the order that was passed by Justice Dashodikari,
Which school?
this is a school, Lordship, that is a tenant. I shall just indicate to your Lordship. Sharoda Vidya Bhavan.
Harda Vidyavan is an added respondent.
Certain teachers and parents had applied. That is from what I found from the tenor of the order.
Order dated?
Order is dated, my lord, 12th of June 2012.
12th of June
2012.
Who are for the added respondents?
No, I am for the petitioner. I challenge the classification of the
Who are for the added respondents then?
one Miss Tonushri Ghosh had taken out an application. I found from the back sheet of the application that she had taken out an application which was allowed.
You are Mr. Lahiri.
No, I am Mr. Devanik Banerjee. I am appearing after obtaining change.
Oh, no, who is then? Tonushri Das.
Tonushri Das.
Has she been intimated?
No, that is what I was indicating to your lordship, because these orders were also not known to us. I just took inspection of my lord's brief out of, so I saw that there was a previous order.
But for charge, we have taken at least 4 adjournments. So there is a specific order, my lord, to take, bring an order from the honorable court.
Who is the other side, sir?
Well, I served them with the copy, my lord. That's will mention today, but unfortunately, court number 24 was having the jurisdiction, the determination today, my lord. But court number 24 did not take up, did not sit, my lord. But the determination came to this court.
Yes.
Well, I given them notice that I would be mentioning before court number 24.
Then
And court number 24 did not sit, my lord, today. But the determination came to this court. Well, I will mention, I will be giving them notice. This can
without
be taken up at
in their absence, I cannot take up.
certainly, my lord. Only that it can be taken up at 4:15. Well, I'll give them a notice, serve them a notice, and come back. 4:30.
Very good. Come back.
4:15.
4:15 today.
4:15. But tomorrow, my lord, I don't know whether my lord will have any determination. Determination only for the day, and tomorrow is the date fixed in the court below.
Very good. I will ask them, serve a notice that it will be taken up at
4 o'clock. Great.
4 p.m.
4 p.m.
Yes. তাহলে ওই কোর্টের যিনি
ফাইলটা
আছেন
বার
তাকে
করে
কোনো
Why? My lord, it's not listed. It's not listed anywhere. Well, on the last occasion, I also came to this court.
So
my
it
lord.
was not listed in the it was not
Nowhere it
listed
was
in the
Nowhere it was listed.
কি বলছি গো? You made no endeavor.
My lord, I tried my luck before court number 24. Well, I tried my luck before court number 236, my lord. 236 is not available. Well, court number 24 had the determination, my lord. I tried my luck there. Well, the court did not sit. Well, I'm coming to before this court, my lord.
The original determination with Justice Mukherjee.
Justice Mukherjee.
It was
Dr.
not
Mukherjee.
included in the list.
It was not included in the list. Last week was mentioned. My lord, there I think Mr. My lord Justice Dr. Mukherjee.
এটা আপনাদের প্রশিক্ষণ
But my lord, to the first one, kindly my lord, not today, my exception ready, will serve it in court of item number 3. My lord, only thing is this, my lord. Well, I was a bit late, my lord. My lord, I was present from the beginning, my lord. Only thing, my lord, just my matter was passed over. And my lord, this will not hamper the, my lord, any hamper the business of the.
But other side is Mr. Koeli Bhattacharya and Mr. Shopon.
We are for your petition, my lord. No, my lord. Hello, your lordship was about. Your lordship was.
Exception by other side.
Everything is ready. Come tomorrow.
Yes, yeah, my lord, sir. That is my.
এটা তাহলে কালকে কিছু তাহলে যেমন আছে তেমন থাকবে।
Yes, as the position we.
You are fixing the matter at specific matter. You not.
No, my lord. My lord, kindly. We beg to.
It will remain as it is.
My lord, we
So
beg to
be rest assured. Please be present and
my lord.
if God is kind, I will be also present. What is
30th.
my order?
Your order, Milord, that is not yet uploaded, Milord. It's my junior was there, Milord. It's fixed for witness action of the judgment debtor on the Milord 28th. Witness action was done on Friday, Milord. Mr. Rupak Ghosh was there, Milord. He was questioning the judgment debtor.
Yes.
Milord, your Lordship was pleased to, Milord, continue it on the 28th of March, Milord. I'm only praying, Milord, it could be after 30th of April, March, Milord. That's the only, Milord.
একটা কাজ করুন আপনি আজকে তো হচ্ছে আপনার 7 নাকি গো
Today is 10th, Milord.
ওই যে 10th তাহলে তো এই শুক্রবার শনিবারটা হচ্ছে না ফিক্স ইট অন
But any day in the first week of April, Milord. Any day, convenient to your Lordship.
Oh, I am to fix it. I am to fix it একটা কাজ করুন ইসি করুন তো
If your Lordship so desires,
একটা কাজ করুন 21শে মার্চে এটাকে তুমি মেনশন নিয়ে আসো তাহলে আমি দেখে সেই অনুযায়ী কথা বলবো You have difficulty on 28th.
Milord, from 21st till 29th, I'm in difficulty. I'll be out of Calcutta, Milord. That is the whole personal difficulty, Milord. That is the only thing, Milord. If your Lordship, Milord, passes an order here and now, Milord, in the original side, Milord, your Lordship can always do that, Milord. I've served notice, Milord. I will also intimate the other side. In fact, Milord, my learned friend on the other side was also asking, also praying before your Lordship for a date in April, Milord.
Difficulty is that I am to pass order in open in presence of your other side. No,
Milord, I can, Milord, if your Lordship so directs me, I can intimate the other side that this has been rescheduled to this date. In the original side, if your Lordship, Milord, kindly treats it as on the day's list and pass an order also.
আমার তো রেকর্ডিং অফিসারও কেউ আসেনি Would it be possible to ask your other side to come at 2 p.m. tomorrow?
Yes, Milord, we shall. Definitely
একটা কাজ
tomorrow.
করো আগামীকালের জন্য এটাকে টু বি মেনশন দিয়ে দাও আগামীকাল
I'm extremely grateful, Milord. I'm extremely grateful. I should intimate.
Yes,
I
you
shall.
intimate. Yes, call the list. Mr. Mukherjee, matter was placed on under the heading to be mentioned on the last occasion when you were not present.
I could not follow the list, and also
Which is why I requested Madam Faria Hussain to serve a notice upon you. আমার এই জাজমেন্টটা কোথায় আছে এখানে
actually I was installed with a pacemaker, my lord. I am the last month, 1 month I am seeking.
এর বাকি পেজটা কি হলো আমি পেজগুলো এসেছি পেপার বুকটা কোথায় গো বললাম পেপার বুকটা কোথায় Mr. Chatterjee, uh, no, Mr. Mukherjee. You are Mr. Mukherjee, no?
Yes, yes.
I'm sorry. Mr. Mukherjee MS are present. Where is Faria Hussain, man? It has to come anyway. Uh, your clients have been convicted by the learned trial court under section 324. They were also convicted under section 148, and they were also convicted under section 307 read with 149. But the charges were framed under section 302. Now you have argued on 324 as well as under section 149. So far as the 302 read with 149 of the 148 of the 149 of the Indian Penal Code is concerned, you didn't argue because of the fact that there was no charge under section 307. Now you have to look to the provision of section 222 subsection 3 CRPC. Have you got book?
No.
You have not brought the book. The court is to supply the book. Very good. Take it. Take it. Hey, look at it. 222 subsection 3. Mr. Mukherjee, kindly place. Kindly place, sir.
Yes, my lord. When a person is charged with an offense, he may be convicted of an attempt to commit such offense, although the attempt is not separately charged.
So what wrong has been committed by the learned trial? I believe, though it was hard conclusively, since you did not argue, because you as if you argued that since there was no charge under section 307, it would not be proper for the trial court to convict them under that section.
Yes, sir.
But subsequently on reading, I found this provision. So having the position, I believe an opportunity should be given to both to you and as well as to MS Saha to argue on this point. As otherwise, your client's interest will be put in prejudiced. If you are you ready today, or you will come on another day?
No, I shall come on another day. I am also only informed that the matter will be fixed on 10th.
Yes, yes, very good.
That is, I have come.
Very good. I am fixing it then tomorrow.
My lord, at least 7 days time be given. My lord.
7 days not possible. Either tomorrow or day after tomorrow. You know, I do not keep any part of matter pending. I'm very sorry. Tell me which day will be convenient, tomorrow or day after tomorrow.
My lord,
If I can make myself ready, you being a senior counsel can very well make yourself ready.
as your lordship present.
Very good. What do you want? You want to argue today? Very good. You also ask Madam Faria Hussain to remain present on day after tomorrow. Don't make mention, sir. Let me go in serious. Very good. You remain busy there. I don't have enough. Call the next matter. বইটা দাও।
My lord is willing to know whether that it is acceptable under the law or not.
What I require, you have to argue on that provision as to whether the learned trial court is at all justified in convicting your clients under section 307, though no charge was framed under that section. On the contrary, a charge was framed under section 300. I have shown you the relevant provision that 222 subsection 3 says that when if any charge is framed under a particular offense, for a particular offense, he can be convicted for attempt to commit that crime. And if you accept that, then you have to argue that where is the fault on the part of the learned trial court in convicting the accused under section 307. If you at all accept.
Yes.
Yes, call the next matter.
With the lordship leave.
Who is for the state? Mr. Tirthraj Ghoshal and MS Faria Hossain. পেপার বুকটা কোথায় আছে? পেপার বুকটা দিন। Have you received paper book, sir?
Yes.
Give me a second. Sir, you please take your seat for some time.
We don't have the paper. We don't have the paper.
Why? How can it be? You don't have any paper book?
Ask them to my lord to contact Ms. Hossain, my lord, so that I can assist your lordship.
Ask Faria Hossain madam to come.
My lord.
Pass over. If they don't have any pass over, তাহলে কি করা হবে? Pass over.
For this week, or not for politics.
No, later come.
My husband.
I'm keeping it pass over for some time.
Yes.
The file. কল্যাণী সাহা বলে একজন উকিল বাবু এটাকে দেখছি পেপার বুক নিয়ে নিয়েছে for the appellant on 14/8/2024 তারপরে অ্যাপিয়ার করছেন না ভেরি গুড সব না এদিকে
item 16 I am led by the senior counsel Shekhar Basu. Just now he requested me to pay for an accommodation the first week of April. Accepted.
Again, as per request. So what about item number 58?
Miss Hussain is coming. Already matter over in court number 26 is on the way, my lord. So he's coming.
Senior advocate is waiting.
My lord, I have already.
No, please let me know whether he has received copy of the paper book or not. This much one information I want to know.
Kindly excuse me, I have a matter before court room number 26. So after finishing that matter, I will come. Next matter is fine.
Which one?
62, my lord. It was taken on the on Friday, my lord. Thereafter, your lordship adjourned it for this day.
Very good. Let me you go on. Ask any of your present friend to respond.
থাকবি 62 একটু বলে দিস যে আমি আসছি ঘুরে একদম হয়ে যাবে মোটামুটি কি করবো ওখানে এদের কতক্ষণ চলে দেখি
থাক।
এদের কতক্ষণ চলে দেখি
61.
Your Lordship, I am in this matter.
Who is for the respondent?
Your Lordship.
Is a complaint case?
Your Lordship, complaint please.
I am for saving my.
Paper book ready আছে?
Your Lordship, before just going with the judgment of the learned trial court, I just wants to give the small brief of the matter, Your Lordship.
You take your seat for some time. Let me go through that.
Your Lordship, Your Lordship.
One intelligence paper book is there.
Then
My lord, I have already contacted my lord. Paper book is with Miss Hussain.
only one witness has been examined.
Your Lordship.
You have SEBI Act.
Your Lordship. It's the latest 23.
Yes, sir. Your Lordship. Your Lordship, the whole matter started in the year of 2004 for the month of 1st March 2004 to 38th of March 2004. Your Lordship. Yes. So in this particular year, Your Lordship, in this particular month, there was a script, Your Lordship, in which the share price of that particular script increases to near about 500% in particular 1 month. It was a small amount. It can be say that it's a 1 rupees and whatever that goes to the 85, 86 rupees, Your Lordship. The accused person, the company, Your Lordship, traded in that particular script. At last, Your Lordship, the adjudicating order is there. We have just purchase or sell, it's not clear, Your Lordship, but whatever the difference amount is there, suppose we have purchased the share on the higher price, 86, and we have sold this on 58 rupees, the amount of the which either profit or loss, it comes to around, Your Lordship, 3 lakh something, not more than that. Whatever my trading profit is there. Later on, Your Lordship, the direction was given by the SEBI to adjudicate the matter. Adjudicating officer appointed, Your Lordship, and they initiated the investigation. They have served the notice to the company. The company received the notice. One of the person of the company, the chartered accountant, he appeared before the adjudicating officer and he has submitted the all document. They have just asked for that I have to submit the document in what way are trading. 2003-4, Your Lordship, the trading was on through online portal only. I have to purchase through the broker. My DP account is there. The trading portal is there. I have just gone through with that and whatever I purchase, Your Lordship. What happened in this matter? After 2009, Your Lordship, we did not receive any order of this adjudicating officer by the company, not by anyone. In 2013 onward, once we find out the company is not able to do the business, there is no business at all. 2015, we just applied for the struck off of the company. Voluntary from the MCA record, the company was struck off, Your Lordship. Company was struck off. There's a procedure in the company. Either I can go for the doormat of the company when there is a apprehension that today I'm not doing the business, later on I can do the business. So I can opt for the doormat also. If the company is not doing any business, there is a specific provision of the Companies Act, Your Lordship. If company is not doing any business for 3 years, the MCA can also struck off the company. Only for that reason we applied that there is no business, no profit, nothing there. It's difficult to maintain the company. We applied for the struck off, the company is struck off, Your Lordship. Suddenly, Your Lordship, they just come up with the complaint case. They filed before the learned Your Lordship court. And in complaint case, Your Lordship, they have just come up with the 3 accused persons. One is a company which was not the existent on the time of the filing of the complaint. Second is the one of the director who was in charge of the company in the year 2003-4, Your Lordship. For 1 month, once the trading was there, I'm not denying that. But Your Lordship, here, the accused number 3 was not the director on that moment. I have the document, Your Lordship. It was just. No, I cannot show that. I cannot see the document. Your Lordship, see only the exhibited document. Your Lordship, it was submitted before learned court, Your Lordship. What is the offense with which you are charged? Your Lordship, the only offense is that the penalty amount which was imposed by the adjudicating officer was not paid by the company. So, this is the only charge under section 27. Your Lordship. Adjudicated by the adjudicating officer. What is the mode of its recovery? Your Lordship. In the event an adjudicating officer come to a finding that you are liable to pay penalty, Your Lordship, what is the mode of recovery?
Your Lordship, the mode of recovery is that against the company, you can go for the either for the winding up, recovery of that amount. This was the only provision on that.
Non-payment of fine is itself an offense.
Your Lordship,
Non-payment of offense is
Your
itself an
Lordship,
offense.
Your Lordship, non-payment of this particular thing is offense under section 27 of the CB Act. But provided the particular directors should involve there. Your Lordship, section 27.
Where a contravention of any of the provisions of this act, or a rule, regulation, direction, order made thereunder, has been committed by a company, every person who at the time of contravention was committed was
Your Lordship, I'm just interrupting for.
was responsible to
Your Lordship,
the
I'm just.
company for the conduct of the business as well as the company shall be deemed to have the contravention and be liable to proceed against. Nothing in this contains or render in this person.
Your Lordship, here.
Yes.
Your Lordship, here the charges against the accused number 2 and 3, it's related to that. They were the director of the company, Your Lordship. I'm just reading against the section 27, Your Lordship, where a contravention of any provision of this act or any rule, regulation, direction or under made thereunder has been committed by a company, every person who at the time of contravention, Your Lordship. I'm just pauses for a moment. There's a specific thing. The person should be there on charge at that moment when the offense occurred, Your Lordship. Here, the second director was not on the charge on that moment. He joined the company in the year 2006. The facts cannot be ignored, Your Lordship. The specific provision clearly stated thereafter, Your Lordship, was committed, was in charge, and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly, Your Lordship. Here, Your Lordship, not a single piece of paper is there, single evidence is there that the directors are liable for that. Everyone is doing the trading in the shares, Your Lordship. We don't know what will happen to that share. Anytime the share price can increase or decrease. There is no complaint against me that whatever I traded, it just lost to the public, Your Lordship. Provided that nothing contained in the subsection shall render any such person liable to any punishment provided of this act if he proves that the contravention was committed without his knowledge, or that he had exercised all the diligence to prevent the commission or omission of the charges.
The charge was framed against whom?
Against the, Your Lordship, the accused persons, Your Lordship, the directors, 2 directors and the company. First, they have filed, Your Lordship, 3 accused person was there. Once they find out.
Trial court frame charges against whom?
Your Lordship, against the accused number 2 and 3, Your Lordship. Why not against accused number 1? Earlier, the complaint was filed.
Come to page number 7.
Your Lordship.
Have you received the paper book?
Your Lordship, I have given that.
You have also received? Come to page number 7.
Your Lordship.
Please.
I, Prabir Kumar Mitra, the special judge of civil case, do hereby charge you against accused number 2 as under, Your Lordship.
Accused number?
2, Your Lordship. Not accused number 1. Why? Page number 7, accused number 3, Your Lordship. Accused number 3. That you are the director of accused number 1 company dealing in the escape of Bachawat Investment and Finance.
So charge was framed against accused number 3 only?
3 and 2. Against both. Page number 7 and 8, Your Lordship. Page number 7 relates to the accused number 3.
Oh.
Page number 8 relates to the accused number 2, Your Lordship.
That I am asking.
Your Lordship.
Yes.
For Finance Company for 1st March 2004 to 30th March 2004, and price of the escaped are increase of 562% in just 30 days. Calcutta, HON'BLE, Your Lordship. For this reason, SEBI investigate the matter and held liable the company as well as you, Your Lordship. If we will go with the adjudicating order, Your Lordship, not a single whisper about the directors are there. Not a single whisper about any accused directors are there in the adjudicating officer. But here, it's a wrongly, just Your Lordship just place that.
No, you
as
have
well.
not challenged the adjudicating officers, adjudicating authorities' decision.
Your Lordship, what happened? The offense took place in 2004, Your Lordship. Adjudicating order passed in 2009. 2010, I appeared before that. Thereafter, what happened, Your Lordship? The company got struck off. Who can challenge that order? My name is not there in the order sheet, Your Lordship. I cannot challenge. The only company can challenge that adjudicating order, Your Lordship, before the SAT. And what happened, Your Lordship? Not only that, in similar matter, similar order, the challenge before the SAT, the learned SAT just remand back this matter to the same adjudicating officer, adjudicating officer reduce the penalty, Your Lordship.
Understand? The appeal is against the finding of the learned trial court.
Your Lordship.
So where is place the relevant portions where the learned trial court, according to you, committed the error?
Your Lordship, this is the first error, Your Lordship.
Learned trial court frame charges against the accused number 12.
Your Lordship, again, for this reason.
Violation of the Commission of Office under section 24, subsection 2.
Your Lordship. And held liable the company as well as you and pass an adjudication penalty of 25 lakhs, Your Lordship. This 25 lakhs only pass against the company, not against me. Your Lordship. Wide order number such and such, May 8, 2009, and accused number 1, and you have defaulted on payment of penalty within 45 days. Now it comes to me. I have defaulted to make the payment of the penalty only. This is the charge against me. Only under section 27. I am no way related to the other sections, Your Lordship.
Show me the relevant portion of the evidence.
Your Lordship. The order.
Challenging the order of the adjudicating authority, have you preferred any appeal? No.
No, Your Lordship.
So you
I cannot, Your Lordship.
So that you are not the person responsible.
Your Lordship.
Show me the relevant portion.
Your Lordship, instead of that, I have to show that I was not the person responsible, Your Lordship. It's a duty of the Your Lordship, the SEBI, to prove that I am responsible.
Of course, it is carriage of proceeding is upon them.
It's a there, Your Lordship. If they will just anywhere, a single piece of paper is there, if I am responsible for that, I will go down before Your Lordship. Not a single piece of paper is there. The only charges against me, I did not make the payment of the penalty there. Under section 27, it's only applicable to the directors who were in charge on that moment. The accused number 3 was not the director on that moment. It's there, Your Lordship. If Your Lordship just permit me to, I will just read the judgment, Your Lordship. What passed against me, Your Lordship?
First, place the evidence.
Your Lordship, I was not involved there. How I can place the evidence? It's their duty to place the evidence that I was the responsible. I don't have any piece of the paper of the company, Your Lordship. I was not involved there. From where I will just get and collect the evidence, Your Lordship. It's not my duty to place that. It's their duty to show that.
Is not available in the paper.
They don't have single witnesses there. The witness who was not on that moment, any officer of the company. He was the person who was just going to file the complaint case. Not a single witness here who can say that I was the responsible on that moment.
The appellant, you being the appellant, you will not argue on the evidence.
Your Lordship, how I can argue on the evidence, Your Lordship, once I was not there. I don't have anything, Your Lordship. I was not involved there. And simultaneously, the two proceedings initiated against me. They issued the recovery procedure.
Please.
Your Lordship.
This is an appeal against your conviction.
Your Lordship, I understand that.
So, if it be your case,
Your Lordship,
that the learned trial court convicted your client on the basis of no evidence,
Your Lordship,
you say that your oral argument is sufficient.
Your Lordship, I will just show that what I
Sir,
submitted.
try to understand my question.
Your Lordship.
Rightly or wrongly, your client has been convicted.
Your Lordship.
You say that before the learned trial court, the SEBI has miserably failed to prove that the accused persons are in charge of the company.
Your Lordship.
It is your contention?
Your Lordship.
Your next submission is that you don't want to place the evidence
Your Lordship.
to show the alleged wrong committed by the learned trial court in coming to a decision.
Your
You
Lordship.
are saying
Your Lordship.
you are taking that risk. I will record that you submitted
Your Lordship.
that since the learned trial court committed error, so and though you have challenged the appeal, you don't want to place the error which is available from the trial court record. That you will.
No, Your Lordship, I have to place that.
So
Your
who
Lordship.
are
I'm going to
restricting
place
it?
that, Your Lordship. Your Lordship.
How muskil?
Your Lordship.
You are saying my client is not guilty, allow the appeal.
Your
I will allow the appeal.
No, Your Lordship, here the page number 9, Your Lordship. The deposition of witness number 1, Your Lordship.
For the first time, I'm saying.
The only witness.
I'm hearing
Your
such
Lordship,
submission.
Your Lordship, here what happened, Your Lordship.
Forget about what happened.
Uh,
I want to learn from you what has happened
No, Your Lordship.
and
It's
what wrong has been committed by the learned trial. You say learned trial court has committed wrong, so client may be acquitted. Very good. Take your seat. I'll hear you and pass the judgment.
Your Lordship.
Take your seat.
Your Lordship, kindly just provide me, Your Lordship. To come up with the facts, Your Lordship. To come up with the facts, Your Lordship. Page number 9, Your Lordship. PW1 witness here. Deposition of witness number 1.
Now come to the point.
I'm just placing that, Your Lordship. I am the complainant of this case and I have filed a written complaint against the accused company Purva Traxim Private Limited along with the directors Piyush Kumar Chaparia and Amit Datta. Initially, the case was filed before the Chief Metropolitan Magistrate, Calcutta. Subsequently, it was transferred Metropolitan Magistrate 20th Court during pendency of the case before the SAT court. The record of the instant case was missing and could not be traced. Your Lordship. Out and as per the order of the learned Chief Judge City Section Court, Calcutta, the entire record was reconstructed. It was not informed to us. No notice was received by any accused of the person that they are just
Not
going to
required.
reconstruct.
Not
It's not required. The copy of the complaint was filed for reconstruction of SAT case, and it's said that the copy of the written complaint, this is the Xerox copy of my signature in every page of the written complaint. The written complaint is marked Exhibit 1. Also, file the list of the document. It is the Xerox copy of the SAT list of the document, which is bearing my signature. It is the photocopy of my signature. The list of the document is marked Exhibit 2. I have also filed the power delegate to me by Mr. C.B. Bhave, the chairman of SEBI, and this is the computer generated order issued to the Securities Exchange Board of India, which is marked ST. I have also filed the adjudication order being SD number such and such, dated 8th May 2009. The original adjudication order was filed with the written complaint, and as the record was missing from learned CMF court, it has been reconstructed. They have reconstructed the original order also. How they have reconstructed, no one knows, Your Lordship. Whether it has been from by the same adjudication officer, whether he was there on the job or not, no one knows that. I filed the certified copy of the SAT adjudication order in the certified copy adjudication order and certified by me, which is marked Exhibit 4. The accused company and its directors did not comply the order passed by the adjudication officer within the stipulated period, and as such, I filed the written complaint against the accused company and its directors being authorized by the SEBI. Here, Your Lordship, there is just making the statement. Its company and its director did not comply the order passed by the adjudication officer, Your Lordship. They did not mention anywhere what way they have communicated to the director of the company regarding this order, whether he has to comply or not. Not a single piece of paper is there written against the accused company and its directors being authorized by the SEBI. The adjudication order was served upon the company and the company received the same, and it is the copy of the SAT receipt. The original receipt was in the record, but it was missing from the record and the record was reconstructed. I'm not disputing that. I'm accepted. You may have served this adjudication order to the company, but you did not mention that you have served this adjudication order to the directors also. It was not served to the directors. There is no provision. Once the directors just join the company, he will be the lifetime director in the company. They are merely the one of the officer of the company, and generally according to the business and whatever the understanding with the promoters and shareholders, they can anytime change the directors. They have simply just communicated this order to the company. The company, which is not the accused, I will show that in later on, Your Lordship, from their statement.
এটা দাও তো ফার্স্ট ফাইলটা দেখি ফার্স্ট এন্ড সেকেন্ড ফাইলটা দাও yes
I filed of the said receipt, which is marked. At this stage, the learned lawyer for the SEBI has filed an application, praying for time for filing to file application for striking of the name of the company from the case. Your Lordship, the prayer is allowed. Accused number 1, company. You have served the notice to the accused number 1, company. You did not serve any notice to the directors, and here you are praying for struck of the name of the accused number 1, company, which is in main default. The allegations against the company. Who were the director at the moment, Your Lordship, and they were the responsible for that? But how they can do that? Your Lordship, deferred as the payer under public prosecutor representing the SEBI, dictated corrected, Your Lordship. Here, the main accused person is no more in existing in complaint case. They have to recover this amount from the company first. You did not recover that, whether the company was able to make the payment or not. Maybe the company earlier, you will just go through the winding up procedure against the company. Maybe you can recover something. So you did not just follow the rules and regulation and guidelines. You did not do your job. You were sleeping for long, at least 7, 8 years, and suddenly you just woke up to only save your job and whatever, and you have just come up with the complaint, say simply, Your Lordship, and file the piece of paper only with this adjudicating officer order and nothing else, Your Lordship. Thereafter, your examination of Chief of PW1 is resumed today. After receiving the said adjudication order, the accused persons did not comply the adjudication order, nor made any contact with the Eastern Region Office of the SEBI. The written complaints has here also they have saying ki we did not contact it to the SEBI. How we can contact once we don't have any information from your side? The written complaint has been filed against the accused persons for non-compliance of the adjudication order, and I pray for appropriate punishment of the accused persons for non-compliance of the adjudication order passed by the SEBI authority. So this is the only charge against me for non-payment of the penalty amount. There's no other charge that I was involved in the any fraudulent activities, and whatever what was the fact, it's in no way related to me. As Your Lordship has stated that I should not go in the merit of the matter. Now I am posted an Assistant General Manager CB, and the head office such and such was posted legal officer, Calcutta, to file a written complaint. So the CB authority has given a delegation power, and I filed the same before the which extension number 3 years. Here, Your Lordship, kindly just have a look on page number 11. Cross-examination of PW1 is resumed today. That is on 11 June 2019. Before filing the complaint, I have gone through the adjudication. I filed the complaint as per the SEBI Act under section 24(2) of the SEBI Act for non-compliance of the adjudication order by the accused company. I have relied the adjudication order passed by the adjudication officer. It is fact that it has been mentioned in the adjudication order that the accused company is a client who had traded in the script of Mrs. Bachawat Investment and Finance Limited. The SEBI is a regulatory authority of the security market. All the scripts are kept by the stock exchange. Any person who complies with the rules and regulation can open trading and demat accounts and can trade in the stock. I admit that the stock exchange consisting of client and brokers. I am the client. I traded through the brokers. He admitted here. I do not know whether the client has any power to control the price of script, Your Lordship. Here, Your Lordship, all matter ends here. He accepted that whether the price of the script, whatever the fluctuation is there, whether it was in my control or not. The only allegation against the company that we have just traded at that particular script, and the script price has been just gone through 500% and whatever. Every day we are just seeing in the market. The price goes to your lordship many times and there has just come back to a 0 rupees or 5 paise and whatever. It's a depend upon the business of the company. Your lordship,
That
here,
has been adjudicated by the adjudicating authority.
your lordship, here he accepted
That
that.
you have not challenged.
Your lordship, I cannot challenge that once the company is not in existence, your lordship. Only company can challenge that before the learned said. That was the difficulty, your lordship. I just gone through the each and every place. They just issued the recovery certificate against me. I have given each and everything to them that this particular recovery certificate cannot go against me. I have just given the all details. Not only that, if the company will
Sir, confine your argument within the periphery of the materials
Your-
which are
your-
available in the trial court.
your lordship, it's there in my submission, which is recorded by the learned trial court. It's there in the judgment. Before passing the adjudication order of SEBI, serve the copy of the notice to the accused person. After issuing of the adjudication order of the SEBI, accused notice upon the accused person asking them to pay the penalty amount within 45 days from the date of the passing of the order. And for non-compliance of the said order, the present case has been filed. No notice has been issued separately by the SEBI to the accused person before filing of this case.
Yes.
No notice served to both of the directors. Adjudication order passed on 8 May 2009 and the present case has been lodged on 29th of August 2013. Not a fact that no notice was issued to the company by the adjudication officer before passing the adjudication officer. I cannot go into the merit of the adjudication order passed by the officer at this stage. Just a restrictive case, Your Lordship. Your Lordship, now the all owners comes to me. I have been examined, Your Lordship. Now it's on page 12, Your Lordship. As I was not aware about the anything, Your Lordship, my reply was according to that, Your Lordship. Have you heard the evidence that's produced? I say yes, Your Lordship. Whatever, it's a page 12. Page 13, Your Lordship. Each and every time I just repeated that I am innocent. And later on, Your Lordship, it's there. 8 question was just, they have just said, they said, all the question, it's no way related to the whether I have done any fraudulent activity there or not. There's not a single question is there, Your Lordship. It was only related to the.
Give me a second.
Your Lordship.
Yes.
Your Lordship. So both accused were examined, Your Lordship. Only at the second accused at page number 19, Your Lordship. Would you say anything before this learned court? So he has just stated, the statement is there. I was the director of the accused company. On Devesh Upadhyay. One Devesh Upadhyay.
Page.
19, Your Lordship. 19.
What is that?
Your Lordship, the statement of the accused person on the time of the examination, Your Lordship. It's a last paragraph. It's question number 16, Your Lordship, page 19. Would you say anything before this learned court? I was the director of this accused company. One Devesh Upadhyay told me to pay rupees 2,000 per year to become the director, Your Lordship. The directors, was there the dummy directors, Your Lordship? The promoters were paying the 2,000 per year, Your Lordship, and they were remain as a director. Who was that particular person, Your Lordship, who has engaged them? The Devesh Upadhyay, Your Lordship. Later on, we just examine the things.
I understand your contention.
Your
But
Lordship.
what is the fault at the part of the learned trial court that I intend to know?
Your Lordship, first thing that once the submission was there, the particular accused number 3 was not the director on that moment. The section 27 is not at all applicable upon the
You are appearing on behalf of the appellant number 3 only.
2, 3 both, Your Lordship. First, I am
Huh.
taking the case of 3, Your Lordship.
Huh.
Once it has been recorded that he was not the director, 27 is not applicable at all. I joined in the year 2006. This particular trading and whatever, it's related to 1 month period in the 2004, Your Lordship.
According to the complainant,
Your Lordship.
how you have committed the offense?
They are admitting me as the on charge on that moment, Your Lordship. This is the factual error, Your Lordship.
Admitting or alleging?
They are just admitting that I was not there. It's their wrong interpretation that I was a director on that moment. The record says that I joined in company in 2006.
So show me the relevant portion of the evidence
Your Lordship.
where they have admitted that you were the
Your Lordship.
you were the director of their company at that material time.
Your Lordship, Your Lordship.
When the alleged illegality or irregularity took place.
Your Lordship, it's a page 7, Your Lordship. That you are the director of accused number 1 company dealing in the script of
It is
such
the
and
evidence of
such.
PW1.
Your Lordship. It's their evidence, Your Lordship, where they have stated that I am the director of the company.
Page number 7 is the PW1.
PW1, Your Lordship. Only on that basis the whole order passed, Your Lordship.
You are practicing in this court.
Your Lordship, this is the only thing, Your
No, I am
Lordship.
asking one thing. You are practicing in this
Your
court.
Lordship, Your Lordship, I know that. Your Lordship,
No, page number 7 is a deposition.
it's not deposition, Your Lordship. I'm just showing that the statement of the PW1, Your Lordship.
इसमें बताओ English, Hindi or Bengali or Sanskrit इसमें बताओ.
Your Lordship, Your
I
Lordship.
can understand my question.
Your Lordship.
PW7 is an evidence.
No, Your Lordship.
Then what you are saying?
I'm just showing the factual aspect, Your Lordship. I cannot go beyond that, Your Lordship. That is the difficulty. My deposition is there, Your Lordship.
What is section 27?
Your Lordship, section 27 clearly said that
Kindly read, sir.
if company is not
Kindly
able,
read, sir. Kindly
Your
read.
Lordship.
I want to learn.
Your Lordship, I'm here to learn from Your Lordship. And
No, sir. You learn.
it's my privilege, Your
Which is why you say that charge is an evidence.
No, Your Lordship,
Evidence is a judgment.
Your Lordship, in my deposition,
Sir, kindly
nothing
read
is
the
there,
section
Your Lordship.
27.
That is the difficulty with
Kindly,
me.
sir, read section 27.
Your Lordship. Where a contravention of any of the provision of this act or any rule, regulation.
Sir, I'm hearing an argument.
Where a contravention of any of the provision of this act or any rule, regulation, direction or made thereunder has been committed by a company. Every person who at the time the contravention was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be.
Stop there.
Your Lordship.
Come to the evidence.
Your Lordship.
Come to the evidence. Do you, sir, come to the evidence once.
Your Lordship. Your
Do you
Lordship.
know in which page it is there?
Your Lordship.
At which page, from which page evidence starts?
Your Lordship, it's a 9 onward.
Is there any averment to that effect? That who was in charge of the company at that material time?
It's not there, Your Lordship.
So who will say this, you or me?
Your Lordship.
Sir, have you read your brief?
Your Lordship, later on what?
In your deposition, that such and such person were the person responsible for the offense?
Answering that, but yes, yes.
No, answer to that question first. Section 27 says that contravention by the person responsible. Where is the deposition to that effect?
In Spain,
Huh.
at that time, the
Yes, sir.
company and its director did not comply the order passed by the adjudicating officer.
Of course, I also accept that.
Yes.
But who are the directors?
Either. That is why I'm submitting lordship. Lordship, before that, Dr. kindly come to Exhibit 1, written complaint.
Huh.
There we have stated.
Oh, in that written complaint, you need not state to there is no need to state in your evidence.
Record that the director was the directors and directors are the person.
That is the complaint.
The complaint is against the three persons initially. The
No, how do you, before the learned trial court, how did you prove that those persons are responsible for the offense committed?
Yes, madam. That is why I'm.
So,
Yes, madam. Admittedly, lordship, the case is filed only on the point that the adjudication order was not complied by the company and its director. That is our case.
which is why some two persons have been charged with the offenses.
Now, in order to prove our case that it falls within section, which is a non-compliance of section 24(2) of SEBI Act, and also attracts the vicarious liability as it is under section 27. So, in order to prove the violations, we have exhibited the adjudication order. That is actually the cause of action from the date when the company and its director violated the order. That is our case. Not that they have violated such and such provisions or they have raised money illegally. That is not our case.
Sir, I understand. Where is your positive evidence before the learned trial court that this gentleman and this gentleman are the directors of the company? These are the document that I intend to do. Where from will get that?
Now, in order to answer your lordship query, my lord, whether they are the directors or not, that is we have to the SEBI has to prove.
Yes.
Whether these persons were the director at a relevant point of time.
Either by adducing oral evidence or by documentary evidence.
Now, it is admittedly, they have stated that they were the director at the relevant point of time in the memo of appeal also, as well as in the 313 when the examination was done, they have admitted that they were the director. As my learned friend, by record the page number 13, page number 9, page number 19. That we find from the statement made under section 313 the particular accused stated that he was the director. He was the director. So if they were not the director, they have to make some suggestion at the, when the deposition was made, when the, kindly see the trends of cross examination. They are neither, they have stated that they are not the director of the company.
Why they will say?
Yes, my lord.
Unless you have said this, well, they will say.
You have said that they are the director and the director are the responsible for the conduct of the company.
Sir,
They have
for the
stated-
you just give me a second. It is your case
Yes.
that the company has violated the provision of section 24, for which penal section is attracted under section 27 against the company.
As well as 24 what subsection 2.
Of course. So you are to say the company is the defaulting person, juristic person, and such persons are the person who are in charge of the company. I want to say, where is that evidence?
My lord, so far the evidence is concerned, my lord.
Burden is upon whom?
Burden is upon us, Lord.
Sir, where, just show me the place where you have stated.
First of all, in our written complaint, we have stated that is
Written
also,
complaint is not a substantive piece of evidence.
that is also exhibited, my lord. And so far the evidence is concerned, lordship.
You said nothing.
No, my lord. We have the complaint filed, we have filed the written complaint against the accused company along with the directors, Piyush Kumar Chaparia and Amit Dotto. We are the directors. We have filed the complaint. It is at the first introduction line, lordship, at page 9. They are the directors. We have stated, we have filed this complaint.
Simply your assertion will serve your purpose.
No, my lord, this is not assertion. This is the deposition. I am the complainant of this case at page 9. I am the complainant of this case. I have filed the written complaint against the accused company along with director such and such. Initially, case was filed before such and such. Then, my lord, come to that the company and its director did not comply the order passed by the adjudicating officer. The person who was the director we have stated.
Sir, come to section 330. CRPC.
Madam,
You have 313, sir?
yes, madam.
Kindly place.
Power to examine the accused in every inquiry or trial for the purpose of enabling the accused person to explain any circumstances appearing in the evidence against him. The court may at any stage without previously warning the accused questions as the court concerned nature.
Yes.
B. Shall, after the witness for the prosecution have examined and before he is called on for his defense, question him generally on the case, provided that in a summons case where the court has dispensed with the personal attendance of the accused, may also dispense with the examination under clause B. Now, in our case, clause B is attractive because it is done after examination. So, in our evidence, we have stated, my lord, they were the director. The person who was the director, we have stated.
So, in the 313, according to you, learned trial court has drawn attention of the learned, has drawn attention of the accused with regard to the incriminating materials.
My lord, may I read the 313?
Yes.
From question 4 onward.
Very good.
PW1 has stated that we filed written complaint against you. What is your explanation? I mean, because we have stated in first line of our deposition that the case was filed against the company and the accused person we have named them. PW1 stated initially the case was filed before the metropolitan and subsequently it was transferred. The record of the case was missing and the entire record is reconstructed. What is your explanation? PW1 stated that the copy of the complaint was filed for reconstruction and he has applied for the state complaint bearing his signature. State complaint marks PW1. What is your explanation? Innocent. PW1 stated that you have also filed xerox copy of the document which has his signature which is marked HB2. What is your explanation? I am innocent. PW1 stated that he filed the power of the allegation which in mark exhibit C. What is your explanation? I am innocent. PW1 stated that he has filed certified copy of the adjudication order. What is your explanation? I am innocent. PW1 further stated that you did not comply the adjudication order within stipulated period. Got it. Question number 10. I am innocent. Question number 11. PW1 further stated adjudication order was served upon your company and the company received the same and he has failed and filed and put the copy of the receipt which is marked exhibit 5. What is your explanation? I am innocent. These are the relevant portion which is our cause of action of our filing the complaint is lost because our case is that adjudication order was passed, that order was not complied. That is our case. When the adjudication order passed, that was communicated in exhibit 5, that is
Question number.
question number 10. 10 and 11. And 12 is also relevant.
It has been stated that at that material time you were in the charge of the company. You are the director or you are the charge of the company.
No, my lord, that is no, it is not stated that you are the director. It has stated question number 4 that the complaint is filed against you. That is there. Not as a director or not, that is not mentioned.
Then
Specifically, it is not mentioned.
who are you?
But-
It may be you and me also.
No, but PW1 has stated that you did not comply the adjudication order, and question number 11 also states that the adjudication order was served on the company and failed. And question number 12 also, you did not comply with the same. If you will kindly see the section 7, subsection 2 of section 24, it starts with any person. It starts with any person fails to comply, fails to pay the penalty imposed by the adjudicating officer.
Section
24 of CBI. Starts with any person fails to pay the penalty imposed by the adjudication officer or fails to comply with any direction or order. This shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 10 years and so on. And section 27 is the provision for vicarious liability, Lordship. Lordship, Lordship, kindly see the trend of cross-examination. They have not even made any suggestion that they were not the directors of the company at any point of time, or the prosecution.
No, have you laid any substantive evidence to that effect? That I intend to.
Lordship, we have stated
That at the relevant point of time, they were the directors of the company, and as such, they are liable to pay the fine, whether that any question has been, any material has been placed.
Other than the adjudicating, Lordship, whatever the document we have exhibited, that is people Lordship.
Take down.
Now, so far the director is concerned.
That's all. That's all. of my judgment. নিয়ে নেবেন সাবধানে হ্যান্ডেল করবেন হ্যাঁ The passover, call the passover matter. He's waiting for a considerable length of time. Item number 57. Dilip Kumar Dey and another. Oh, 58. I'm sorry. 58. Your matter, sir. Where is madam? Then I'm making a not today. Not today only. Yes. একটা কি ম্যাটার ছিল ওই জাস্টিস মুখার্জির কোর্টে নিয়ে নেবে করে নেবে তোমরা CD is available.
CD is not available. CD is what happened. There was order of stay at first. But that order of stay.
Let me see. Which for the state?
He could come at that.
Is a complete case?
The complaint, no, the GR case.
GR case.
No, my
I believe
this
my
is a
lord-
very,
My lord,
very
the-
old case, my lord. I am not holding the brief, my lord, now, but I am in this matter on behalf of the state, my
Yes,
lord.
my lord, that is an
State and the opposite party number 2 is the complaint. Not the fact.
my lord, I am for the opposite party number 2, my lord. Why?
Right, order dated below 14/3/2022.
Opposite party number 2 is the de facto complaint.
De facto complaint. My lord, the problem is, my lord, today it has been fixed at 4 p.m. My lord, we don't have the brief right now, my lord.
Without CD, how can I give you the
We were enjoying what I see. We were enjoying a stay.
very good?
So the stay expired here on there till 31st of January 2024. Thereafter, it was changed brief, we received the brief, but it was never extended. But tomorrow is the date fixed for charge.
Let the charge be
My,
paid.
my deepest
Let the
submission, my
charge be
lord,
considered.
there is
So what is the difficulty?
CRAN application pending, my lord, as well.
Where is the difficulty, sir?
You have not filed any extension of pending, my lord.
Then
Without application.
We have taken at least 4 to 5 items. Order.
no, if you are at all serious, you could have you could have mentioned before the trial court for extension of interim order, or you could have approached the learned trial this court by filing an appropriate application.
But what happened was, yesterday I received the brief.
Very good. Sir, sir, when a court talks
Yes,
with
certainly,
a
sir.
counsel, he practically talks with the client.
What has happened?
Since you have been appointed yesterday or day before yesterday, your client cannot get any extra advantage, sir.
What I say, only a one line order may be passed. So that I can seek adjournment only for the day tomorrow. I can seek adjournment only for one day. I'll come back with the matter with the regular bench. This will serve the purpose. I cannot I cannot extend this stay. I cannot move the matter at this moment. Only an order, one line. I can take an
My lord,
adjournment.
my lord, kindly ask him to
I'll serve a
The
copy.
matter is treated to be
have a
Yes, misplaced.
There is no CRAN application.
Misplaced.
Nothing at all, my lord. No extension of window order.
the matter.
Not grateful.
Yes, call the next matter. $16.05 you are seeking a pass over. What is the name of the senior? What is the matter about? What is the matter about? You are not junior to him. What makes you laugh, sir? You are not junior to him. You are his Simba junior. You have not gone through the brief. Why? Why? How long you are practicing? 1 year. Then at least you make yourself aware of the facts of the case. Senior remains busy in other court is a boon to the junior, so that they can get an opportunity to open their mouth. Why are you not availing this opportunity? This court do not expect much from you, but at least you should make yourself aware about the facts of the appeal. What is the written complaint? What are the under what provisions of law charge sheet has been submitted? What are the charges? Who are the prosecution witnesses? What is the relation with the victim or the accused? Have all the charges been proved before the learned trial court? Sir, simply shaking your hands will not serve your purpose. Everybody is your competitor in this profession. Keep it in your mind. Not today. Who is for the state? You are Mrs. Sujata Das. What happened to you, madam? You missed the track.
Actually, unless this paper book has not been allocated, how can we help you? And
Mention that before this court that
I already mentioned it. And after that, Malak, we are watching Malak. Either Jodi for me.
now advocate for the appellant is yet to collect the paperwork from the department.
No, Malak, we have already collected.
Collected?
Yes, sir. Already collected. There was a statement of the appellant.
Who is for the appellant?
I am for the state.
State has collected the paperwork.
Collection.
আমার paperwork এইটা It is not compoundable.
Comfortable manner. Also comfortable manner. And the appellant already paid the amount already. After that, conviction.
The misfortune of your appellant is the defense side, prosecution, or the learned court below never looked into the relevant provision of law while passing the judgment. Kindly come to 152.
One electricity act, give me, I don't have. You have paid the amount?
Not very next day, amount has been paid.
Still conviction order has been passed.
Yes.
Section 2 and 3, subsection 2 and 3.
Very small case.
Which one, sir? 152.
52, subsection 2 and 3.
On notwithstanding anything contained in the substance, sir, the approval by may accept from any consumer or person. তাহলে তো এদেরকে সার্ভিস করতে হবে। You have made the de facto complaint party? No. No. Discom? No.
No.
They should be made party.
But
Discom should be made party, na?
the problem is they change the melody. The land and advocate of that. Making it party.
Who is the informant?
Informant is the law is the assistant engineer.
He should be made party.
His name or the he must be melody by
No, by designation.
designation.
আসুন। You have deposited the amount.
It is in the order sheet itself.
In the deposition, like,
London advocate stated to say. It is there in the order.
like page 7, Malad, complainant himself stated that he already deposited.
Then
2978 the revenue already deposited. Last paragraph, page 7.
Page 7 on the chart.
I said notice assessing the provisional loss and Vidyut paid the provisional assessment amount. Hey? উনাকে দিয়ে দাও উনি ওটা দেখে দেখে ওই এটা অ্যাড করে নেবে make an endorsement that added as per leave of this court. Yes, call the next man. You go to your by the side of your senior. He will guide you. Yes, call the next matter. Madam, what
When I'm
happened?
there, the other side is not there. When the other side is there, I'm not. My lord, it's becoming very difficult. My lord, kindly takes this courtroom number 237. My lord, I was in 26. I came all the way. Then, my lord, we have to wait for 2-3 minutes for the lift.
No, I have.
My lord, it's a very request.
I'm telling.
Honest request, my lord.
65, I have got to explain the 430. Kindly make it document.
What is the matter?
My lord,
The 498, 306.
conviction.
Conviction and sentence was passed in 306. 498, no conviction has been passed.
Ma'am.
7 years.
Who are you?
I am for the applicant.
My lord, he's the husband.
Husband. I'm for the husband. I'm for the husband.
No conviction order was passed on the 498.
No, no, no.
Even 306.
Only 306. 7 years.
Making it not today.
Great. My learned fees is.
My lord, I'm ready with
You got the paper book.
Yes, yes.
Come ready on the next day. I shall take
Yes.
it.
Justice 66 for the CBI. CBI is the appellant in this case, led by Mr. Kaldol Mondal. Lordship frame for not this week.
Not this week.
Lordship.
Mr. Mondal is very busy.
Yes, Lordship.
I'm for
Very-
the opposite parties, ma'am.
I'm for this.
In an appeal, there cannot be any opposite party. Either the appellant or the respondent. Very good. Not this week.
Much obliged.
Lordship, kindly fixes it up to 19 because I'm led by Mr. David.
Let me make this not this week. Thereafter, I shall consider.
Much obliged.
Call the next matter. But Dako. Go on calling for. Not possible. Not today.
76, my lord, Mr. Honorable, please appearing on behalf of CBI, my lord. My lord, earlier occasion, my lord, Mr.
CBI is the appellant or the
No, my
respondent?
lord, respondent, my lord.
Who is for the appellant, sir?
My lord, my lord, Lord Senior Advocate, Mr. Basu is appearing, my lord. My lord, the Lord Senior Advocate has filed the, my lord, the written notes, my lord. Paper book is there, my lord. My lord, we are supposed.
No, I am to hear them.
My lord, we'll serve a notice, my lord. We're supposed to, my lord, file the written notes, my lord. It has gone for vetting. Kindly tell Lordship take it up, my lord. 19th or 20th, my lord. We shall file the written state, my lord.
No. Simply filing written notes of argument will not suffice your purpose. I am to hear. Thereafter, I shall, if I require, I'll take. Usually, I do not take written notes of argument.
My lord, then kindly, if Lordship, that is not to serve, my lord, Mr. Basu.
What is the requirement of service? You just serve.
My lord, my lord.
Call the next matter. Sure.
Be taken up by which lordships, that has not been yet decided. So till that is decided, my lord, division bench only will take up the matters. My lord, otherwise it becomes really because my lord